subject, I have a right to say, you can use my data here, you can't use my data here. So when it comes to general penalties, so for companies that do not comply with these provisions, there is administrative fee of 5 million shillings or 1% of annual turnover. There is also a general punishment of imprisonment of up to 10 years and also a fine of 3 million shillings. A perfect example is that of WorldCoin. Now, WorldCoin, I believe, was collecting data pertaining to iris or some particular components of the eye. Court was approached and they actually put restraining order. So the principles that WorldCoin violated is that they never obtained consent from the data subjects. 2, this data was ultimately going to be transferred to the US, but again, no consent was given and they do not put in place safeguarding measures. And lastly, they do not do an impact assessment test to ascertain the risk and possible mitigation measures involved in collecting this data. Some other notable examples include the ones that are there. So again, Roma School, this is where the school put out pictures of the student without consent. I think that is same for Cesar Vera Lounge as well. And the other one was a credit provider who used third-party information to harass the defaulter. Again, you know, nowadays you can't do that. The law does not allow you to do that. Now, moving on to the second issue of consideration is money laundering and terrorism financing. So we find that this is a key consideration for tech companies because figures show that the prevailing rate of money laundering and terrorism financing is actually quite high in the country. So the Financial Task Force grey-listed Kenya, I think sometime in February, because some of the key reasons for grey-listing was that we lacked clear policies and prosecution when it comes to money laundering. And secondly, we had inadequate investigation and prosecution of persons who had been found to finance terrorism. So what is anti-money laundering rules? So in a nutshell, AML, these are rules and regulations that are aimed at uncovering processes of legitimizing illegitimately gained income. I think in Kenya we have a term for it called wash-wash. So anyone who conducts wash-wash, that is money laundering. What is CFT? CFT these are rules and regulations that aim to restrict access to financing for people who have been identified as terrorists. So again, studies show that when it comes to money laundering and terrorism financing, they have a key target of fintechs. So one of the reasons why fintechs are targeted very much is because ease of onboarding and ease of transactions. So one of the USPs of fintechs is that as a customer, I can easily submit my documents, they can easily take me up, they can easily give me money without much bureaucracies that are there in institutional banking and financial institutions. So again, that is a soft spot that money launderers and terrorism financing guys see as an avenue. Another reason is ease of cross-border transactions. So with fintechs, you can see you can easily move, if I have M-Pesa, for example, I can easily move money from Kenya to Tanzania without much, again, bureaucracy and paperwork. But if I was to do that via bank, there are more measures that are put in place. So again, as a person who is involved in money laundering, I see that and I go, nice, that is an avenue I can exploit. So now on the key legislations, I don't want to belabor much on this. We have the Anti-Money Laundering Act of 2009. We have the Proceeds of Crime and Anti-Money Laundering Act and the regulations therein. We have the Prosecution of Terrorism Act. We also have the National Payment System Acts. Again, the National Payment System Acts involves fintech players who are involved in exchange of money. Now, to comply with the regulations of money laundering and terrorism financing in the country, the first objective is that the company has to have an efficient KYC policy. So a KYC policy is policies that are involved in the onboarding stage. So I, as a tech company, let's say I'm a financial service provider, when I'm onboarding this client, do I know that this client, the information they're giving me, one, is accurate, and their source of income is accurate as well? So again, one of the key provisions that tech companies are supposed to be aware of is that when you're onboarding, make sure that you go through the documents that are presented by the potential customer to identify that, one, they are correct, and two, that even the source of income is actually legitimate. Another key consideration is transfer monitoring. So you notice that once you acquire a customer or once you acquire a subscriber, with the passage of time, they do have a transaction history. So let's say it can be on a periodic basis or on a ad hoc basis. So maybe every day or every month I deposit 20,000 and on average I withdraw 5,000. So again, with the passage of time, you as the financial service provider, you as the tech company, you can establish the patterns of your end users. Now, the whole point of this is that when you monitor, you can then easily identify suspicious transactions, which leads to the third aspect of compliance, is that you as a company, you must make sure that you have sufficient policies that clearly indicate how you're supposed to report any suspicious transactions to the, I believe it's the Financial Reporting Center. Another key consideration is appointment of money laundering reporting officer. Again, the money laundering officer just ensures that your compliance with the money laundering policy is actually in place. Penalties include imprisonment and fines within the various acts themselves. So as of 2023, there were some key legislations. These were the Anti-Money Laundering Amendment and Combating of Terrorism Financing Laws Amendment Act, and also the Proceeds of Crime and Anti-Money Laundering Regulations. Now, the key reason of introduction of these policies is that we wanted to kind of ring fence the money laundering activities that have been established to be very prevalent in the country. So some of the key measures that were introduced is that the reporting threshold has now been increased from 10,000 to 15,000 US dollars. So any transaction above 15,000 US dollars now, you have a duty to report it. Reduced reporting timelines on suspicious transactions. So now when you identify suspicious transactions, within 2 days, you're supposed to report it. There's also been an increase in the penalty for up to 50% of monetary instrument involved in the offense from the previous 10%. Then some other ones include now companies are required to maintain records of customers and transactions for a period of up to 5 years. Also, money laundering is now an economic crime. That means if you are actually involved in money laundering, the anti-corruption agency can actually come for you. Also, supervisory powers have been given to the likes of the Central Bank of Kenya, the Capital Markets Authority, and the Insurance Regulatory Authority. So these guys, in the sectors that they operate in or in the sectors that they regulate, they actually now have powers to oversee money laundering policies are actually in place. Lastly, I'll talk on cybercrimes, the regulation aspect at least. I think in the morning, a significant amount of presenters talked about cybercrime, what it entails, again, reasons why we're here. So just a quick statistic, according to Kaspersky's rankings on June 2023, Kenya was globally ranked 35th in terms of incidents of cyber hackings rather. And also there have been reported incidents of key or vital institutions being hacked. This include the Kenya Power and Lightning Company, we have the Kenya Railways Corporation, and the National Transport and Safety Authority. So what are the key legislations that companies should be aware of when it comes to cybercrimes? The first one is the Computer Misuse and Cybercrime Acts. So this is the act that creates offenses pertaining to cybercrimes. So acts such as unauthorized access or interference, false publication, and child pornography have now been made an offense, and you can actually be persecuted for them. So in terms of compliance, companies here should inform the National Computer and Cybercrimes Coordination Committee of attacks and disruptions within 24 hours. So if you have disruptions in your system, within a 24 hours period, you should make sure that you report it to the National Computer and Cybercrimes Coordination Committee. Penalties for non-compliance under this act include imprisonment or fines ranging from 3 to 5 million. Next, we have the guidelines on cybersecurity for payment service providers. So again, we find that most fintechs can be placed as payment service providers. So the guidelines have put in place obligations that they should actually adhere to. One is they should submit cybersecurity policies, strategies, and frameworks to the Central Bank of Kenya. The second one is they're supposed to notify the CBK within 24 hours of any cybersecurity breach. And lastly, they are supposed to provide CBK with reports concerning occurrences and handle quarterly basis. So Muniva, that is it on my end. Perhaps you can continue on the other issues. Thank you.
Now, as lawyers, we are very prideful. So what I will ask is, you have seen, if you knew the act that he read, it is so long that he reduced it to 10 slides. So I will ask, because we are, the wakilis of we read, so you'll need to clap for him, and that's who we are. So please do clap for him before you proceed. I was just playing, but thank you for being an awesome crowd. Anyway, so we'll now segue to consumer protection, as I said, right? And I like giving stories. I think at a time I would have been a pastor, but anyway, besides it. So I will ask just a very simple question, and I'll ask you, you're my favorite audience because you're in front here. When was the last time you read your terms and conditions of any product that you purchased or a service that you opted into? You got bored after the first paragraph. So what was the issue with it? Was it too long? Was it too legally? What was the issue with it? Both. Okay. So now, that is a concern for a lot of consumers, whether in the fintech space, whether in whatever product they buy, right? As long as it is terms and conditions. Because then what our laws require is the terms and conditions need to be very clear, straight to the point, and informing you of what you need as a consumer. Now, that feedback would have been good for you to tell that person or the company, right? Because then what these terms and conditions are doing is they are being explicit to inform you, this is what we are bound by, and this is what we are not bound by, right? Now, as a consumer, if you purchase that particular product or you opt into a service and you do not know that, then they have an upper hand of much later, perhaps when there's a breach. Let me give an example of a somewhat current claim that I'm handling. So this consumer opted into a product. It was a fintech loan product. They didn't read the terms and conditions, and then they defaulted. So much later, they're hit with a demand letter that tells them, this is your credit loan statement, you need to pay this amount. Now, this client was quite aware of what they needed to pay at that time. What they were not aware of is that the interest default had a penalty, and that's the catch. So there's the interest that, so assuming the loan is at 2 million, perhaps for fintech, they'll give you a very small amount. So let's say 50,000. So the interest, the principal amount was 50,000. The interest is maybe 2%. Now what the terms had provided, but in very small print, was in the event you default on the interest or the principal, there's a penalty fee of, again now, 10%. So they didn't know that. So of course, when they hit with the demand, that's the argument, that I did not understand these terms and conditions, I don't need to pay this, and a whole other story. But then we are having now conflicting court precedents, where on one hand, a court of law will agree and say, are you not over 18? Yes. Did you understand the terms and conditions at the time of entering? Yes. So they cannot interfere with what the terms and conditions are saying because it's a pure agreement. But we're having other courts now saying, hold on, fine, I agree that terms and conditions are binding because it's a simple agreement. However, even with these terms being binding, purely on a commercial point of view, it is unfair. And that's why I will segue in terms of unfair terms. Now, unfair terms would be either the interest, because we cannot have a bank having interest, I think now it's 17%, somewhere there, right? 17, 16. I know CBK had, not CBK, NCBA revised their loan interest, but it's thereabout. But then we are having, if I segue a little bit, not just on fintechs, but even loan sharks who are issuing 24% or 34%, then the court says this is too high. We cannot even legally say it is a correct agreement or a valid agreement. So these are the things now that we advise clients, despite the terms and conditions having 12 paragraphs, 13 paragraphs, that is your right to read. You actually have a right, when you're entering into that product or that service, to literally sit down with that customer care person, take as much time as you take, and ask them to break it and dumb it down for you, right? Now, secondly, just even as we proceed with the terms and conditions and the loans, how many, and I'll ask just rhetorical, I don't need any answers, in terms of social media, who's seen the image of spas So just random spurs. So how many, is there anyone who's seen on their feed? You guys don't pamper yourselves? Okay, anyway. So in my feed, I have a lot of spam, what are they called? Page that comes. So I checked it once. I wanted to buy for a particular friend a package. So I checked it once. Now, at that time, when I just checked that particular page, bought whatever I needed to bought, and proceeded with my biashara, right? So much later, when I'm entering Instagram, I now get these pop-ups. So I write to them and I ask them, hold on. So I'm writing to Instagram. Hold on. I'm that person. So anyway, hold on. I didn't, why am I getting this? I knew what my feed had. This is a very total. It's a different. It's affecting my personalized content. So what is happening? So this is what Instagram tells me. When I initially logged into Instagram, and that is way, I won't say because it sounds I'm old, but way. So when I logged in, I accepted the cookies. And the cookies meant I will be sent promotional content on everything, regardless of whether I like it or not. And I tell them, but you didn't explain that to me. I didn't even see that, even me accepting it. So this is what they told me, and that's where now DPA comes in. Well, Data Protection Act comes in. Is the issue of consent. Does anyone here operate an app? You said yes. You operate an app. You operate an app, okay. What, do you have a section that you need to tick a box for a particular, you're opting into something? You do. How does it work? If you just explain to me briefly. Is it, I read the terms and conditions first and then I tick, or I tick and then accept your services?
Tell it, don't show me again, or you just ignore it without checking the box and you continue. Meaning it's going to pop up again. It's going to show you that pop again, or the alert.
It's like these mics don't love me. So the reason I have asked that is, we now have the Data Protection Act that, quote unquote, the consent needs to be explicit. And explicit means I need, as a consumer, to appreciate and understand whatever that I'm consenting to. If it is the professional content, there needs to be like a checkbox, the right tick, and I say, whatever I'm logging into, it needs to be something that I've consented to. And interestingly, that box needs to be popping out each and every time I log in. So it's not the first time that I'll use the service and the next time it's, in fact, if you have realized a number of services or products, the moment you do the first tick, the next time you log in, it doesn't ask you, it's like it's consented for you, which again would not be the consent that is required by law. So if there's anyone here, and that's free advice, so please carry it home, but if there's anyone here who, you're operating an app or you're operating a product that one needs to consent, the tick thing has to be there each and every time I log into your product or your service, okay? So now I'll move to these logos. Now, the reason why intellectual property rights is quite key is because these logos here identify you as a product. Identify you as a brand. So you're having, perhaps if I give an example of Unicaf, Unicaf is known as Unicaf. If you enter a room and you say a Unicaf, that's the business's brand and that's the business's logo. And the reason why it is known as such is because it registered itself. And that's why we as lawyers advise clients, because we've realized there are a number of, and maybe I'm speaking to a number of students in this room, who you'll have the symposiums, the seminars that you're presenting your idea to, whether it's your professor or whomever. And the professor, at that particular time, unfortunately, can't take your idea because there's nowhere that has been written that it belongs to you. So then what we do advise clients at that time, or even students, is just register that particular idea. Now, there are 3 types of intellectual property rights. So we're looking at, so these are trademarks. So trademarks would fall on logos, something that identify you. So for Coca-Cola, the thing. For Safaricom, or this. So that would be registered in our registries, and it would identify you as you're the owner of this, so no one can infringe it. In the event someone infringes it, because then what our law does allow is first person to register it is the legal person. So if I come back the second time and register a particular logo, first of all, the system won't allow because there's already something that's in the system. So that's why we do advise it's good to register. Now, number 2 would be copyright. Literature, articles, whatever, even if it's students who you post on LinkedIn, or you post on, or you have a WordPress, because I know a number of students would post, if it's something that you're really into in terms of literature, and this is your career, in fact, registering a copyright is, it's a minimal amount, it's not too much, same thing as trademark, where the cost becomes a bit high, based on now the industry that you're in would be a patent. Now, a patent would be more or less an invention that you bring to the market. Perhaps you're saying, this is novel, it has never been presented into the market, and you want it. At that instance, based on now the industry that you're in, because each industry has different fees based on our registry, that's when we can advise and say, it's either you register the trademark at first, just to protect that, or register the patent. Now, based on where you're operating, because at times you find for patents, or just for the idea that you want to do cross-border transaction. So you have Kenya, and perhaps, if I would give an example of now the cross-border transactions for fintech, because I think that's the most industry that I think has done a lot of cross-border. Whether it's Visa or it's just money movement in and out. Now for that particular one, given that you want to register that trademark, being the logo, what then we do advise is, just because you're registering in Kenya doesn't mean that it's safe in, perhaps in Uganda. So then what you do is you register again in Uganda. Because then, if the claim is filed in Uganda, you cannot come and say, I filed in Kenya, so I'm safe. So that's the difference advice that we give based on what you're presenting, okay? Now, my last conversation would now fall on Competition Act. Has anyone ever interacted with Competition Act? None. Thank you for being a diligent, just being honest. The rest, you're just looking at me, it's like, okay, anyway. So, let me tell you how Competition Act intersects with tech. So let me give an overview of what Competition Act is. So Competition Act is an act that governs our markets. Our markets in the sense that any person that is operating as a business or a company that is operating in Kenya, there are rules around that so that we are avoiding not avoiding, but we are appreciating safe competition on one hand. And number 2, regulating that market to avoid having a dominant company coming in, pushing away the small companies just because they have a dominating power. Giving an example of perhaps the e-commerce sector. So what ideally they do is, so e-commerce would be Jumia. Let me give an example of Jumia. Jumia and this other one. Give me an e-commerce platform. Jumia. Yes, Kaigarden. So then the e-commerce industry, right? So before they came in, those Masoko. You've heard of Masoko, right? By Safaricom. So then what happens is they will buy data from different industries. Data being perhaps even your Instagram, your feed. So they'll buy that. Now remember, each time you log into Instagram and whatever you like, that's data you're inputting into this particular platform. Facebook, the same thing. Even just simple as Google. And that's why they'll personalize. And during elections, you'll perhaps get a lot of news on the candidate that you searched. So that data, these e-commerce platforms will buy. Now, when they're buying during elections or during a particular event, they will personalize information to you. Nothing wrong with that, but now the problem is they get an upper hand than a mere e-commerce person who is trying to understand the market. So that's how Competition Act comes in. So we have regulators around that who try to now sensitize or perhaps try to just do an industry check to ensure every person in the industry, regardless of whichever sector you're in, is cooperating and ensuring that you're being fair. Now, why the fintech space is hit a lot with the Competition Act is they're way ahead in terms of data compared to, perhaps I'd say, industries that more or less it's not data driven. So if I would give an example, it's like the horticultural industry or the fisheries industry, which we would say it's still a bit slow in terms, as opposed to the fintech, right? So now for those markets, they'll be affected because it's either their economic condition is not improving in that space, and therefore you find e-commerce platforms, fintech platforms are hit a lot. So then what would be my advice to anyone in that area? Number 1, staying vigilant in terms of, so we have we have a regulator, and that's the competition authority, that has been very vigilant, especially this year, in issuing fines to a number of companies. In fact, recently, there was a report that they had fined a company 10% of their business turnover just because they were playing unfair. Google, early last year, or late last year, if I do recall, was also hit with a fine. Now, for Google, of course, it's not under the competition, but the bigger, because you also have an authority, the European authority, that governs competition space. They were hit also with a number of, a number of billions because they were playing unfair. And that is, they would buy the data and enter into exclusive agreements with e-commerce platforms to now sell that data. So then, what then would be my conclusion? Number one, the authority is not playing. That is the truth of the matter. In fact, if there's an year, I would say they have been very high in terms of issuing fines and penalty, it's this year. Perhaps it's a target they're hitting, I wouldn't know. But at the end of it all, staying vigilant. Number two, for startups who are trying to enter the space, the fintech space, and trying to understand what that looks like, I know a number of us fear lawyers. That's the truth of the matter, because you either think we're expensive or we're just in for the money. We are not. But anyway, but that's the misconception, right? And perhaps for some, it could be true, but then what my advice would be, it never hurts you to just speak to a lawyer. I'll kill you a quick one. It never hurts you to do that, because then what you're trying to avoid is you taking a contract from the internet because it said these are the terms and conditions, not applying it to what your business is doing. Only much later, you're now hit with a consumer protection claim. And let me finalize with just one case that I don't know if you're aware of, but it doesn't touch on fintech, but it does give you a clear glimpse of what the court of law can do for consumer rights. So it's, given that it's public, so I will mention names. So it's Coca-Cola versus an individual, just a normal individual, just like you and I. His name was Mark. So he took Coca-Cola to court. In fact, it was Coca-Cola and Nairobi bottlers. So he took Coca-Cola to court and told the court, Coca-Cola is infringing on my right, and this is why. So number one, let me give this disclaimer so that you understand how you have so much power being a consumer. So he doesn't take Coca-Cola, but he took this matter to court and told the court, this Coca-Cola is infringing on my right because this bottled soda that I buy does not have certain information. It doesn't have when it will expire. It doesn't have sugar content. So, sorry? Yes, in fact, it didn't have the ingredients that they should be. So, of course, Coca-Cola says, hang on, first of all, you don't even drink this. So what exactly are you complaining of? Like, let the person who drinks complain, which we don't have. So why are we in court? The court then says, and this is now where you need to appreciate. So we have the Constitution, of course, which allows any person to bring a claim, regardless of whether you're a consumer or not. But of course, there's some thresholds that have to be met. So that's his basis for bringing the claim, that based on the Constitution, I do have a right to bring it on behalf of other consumers. So the court said, okay, fine, I can hear you. Now let's go to which ingredients are you saying. It's very simple things. Sugar content. It doesn't tell me. In fact, he made a distinction. So there's the plastic cup, the plastic bottle, and the Coca-Cola, the bottled, glass bottled. So for the glass bottled, it had all the content. But for the plastic one, it just didn't have the sugar content. And this is what the court said. Regardless of whether this is bottled or this is plastic, both contents have to have the same, because when me as a consumer, I drink this, I need to know the sugar content that is here. Because at the end of it all, truly, let's be frank, I'm sure none of you even know the sugar content in your bottles. But because the law does ask every person who is a business person or company in that area, just disclose every information that is important to a consumer. And Coca-Cola was hit with a very huge fine. They appealed, of course, but they were hit with a very huge fine. So pretty much that's what I'm trying to say. Whichever side you're sitting on, whether you're a consumer, please know that you have your power. And as a businessman, please know the consumer has power. And as well as you need to make things right in terms of what you release to the market. So I think from here, then I will hand it over to Victoria, who will discuss about AI and blockchain. Please clap for me.
Thank you, Muniva. Brian, I I don't fall in the category of gatekeeping lawyers, but I'm in the category of the boring, tea-drinking lawyers. And so before last year, my perception of AI or robotics was they're going to kill us all, they should be resisted. They're like smart fridges that refuse to give you ice cream ice cream when you need to eat and you're having a craving, or robots that fight you in the house. They get angry at you all of a sudden and they fight you and kill you. So that was my perception of AI. And as a lawyer, I said, no, it should be resisted. But last year, I had the opportunity to participate in a global initiative called the Omdina Challenge, the Barcelona chapter, and they requested us to come up with ideas integrating blockchain and AI into various industries. And I came up with the idea of AI and blockchain in the Kenyan judiciary, or an algorithmic judiciary. So I will shed light onto this fascinating topic. I hope it will be fascinating for you. In this ever-evolving digital age, the fusion of AI and blockchain technology holds immense promise for enhancing efficiency, transparency, and trust in our legal processes. However, as with any other technology, they come with challenges. This afternoon, I will explore these challenges and discuss the various algorithmic governance approaches necessary in making the algorithmic judiciary expeditious, efficient, procedurally fair, and transparent. Okay, let us delve into the definition of an algorithmic judiciary. Okay. An algorithmic judiciary is the concept that envisions the integration of blockchain, particularly smart contracts, and AI into our judicial, administrative, and decision-making processes. An algorithmic judiciary has the potential to empower the utilization of algorithms in analyzing vast amounts of legal data, including case law and statutes, predicting case outcomes, providing invaluable support to judges in making well-informed decisions. Additionally, they can automate routine tasks within the court registries, streamlining administrative processes and saving valuable time. However, like I said earlier, let us not forget the challenges this brings. There will be power struggles, implicit bias, corruption, and infrastructure limitations that must be addressed with the utmost diligence, as these obstacles can undermine the very principles upon which our judiciary stands as the deliverer of justice, or the custodian of justice. The principles are like fairness, delivery of justice, accountability, protection of our rights and liberties through dispute resolution. Okay, let us explore the potential benefits. So there is increased efficiency and accountability through the decentralized and transparent platform brought about by blockchain. AI can analyze data and automate tasks, leading to improved efficiency and accountability. The decentralized architecture of blockchain can help prevent systemic failures, ensuring the integrity and reliability of our legal and administrative processes. Smart contracts and AI can enhance document management, reducing the risk of file misplacement or loss, and improving organizational efficiency. And then by leveraging on smart contracts and AI, we can streamline administrative tasks and ensure swift updating of information, such as when a matter is coming up for hearing, through the implementation of electronic court clerks. So enhancement or further automation of existing services, like what we have now, like the judiciary e-filing platform, can expedite filing procedures, reduce bureaucracy, and lower costs, making justice more acceptable to all. The integration of AI and blockchain can introduce supervisory oversight, preventing corruption, ensuring the authenticity and reliability of court documents. There is one problem that really irks me, and that is case backlog. And I believe that AI's autonomous functioning can help address case backlog by randomly allocating cases to judges, magistrates, or any other judicial officer, which thereby mitigates bias and enhances impartiality. Then there's improved case management. AI's pattern recognition capabilities can greatly improve case management practices, particularly in complex litigation cases, providing valuable insights to judges and magistrates. AI can also play a significant role in specialized courts, like the environmental and land courts, assisting in tasks such as legal research and predictive analysis. So the potential challenges that an algorithmic judiciary can bring are power struggles and opposition. If we bring such a concept into our judiciary, we will get a lot of, resistance from our judicial officers, because they're a bit older and they want to maintain the status quo. So this will lead to power struggles and opposition. And as we all know, our governmental systems are full of corruption. And our judiciary is the same. It has corrupt practices. And these persistent corrupt practices can undermine what the algorithmic judiciary seeks to uphold. So there can be infrastructure limitations. Inadequate physical and IT infrastructure can hinder the timely development and implementation of these technologies. And decisions made by judicial algorithmic officers may lack legitimacy, as they may not be rationally acceptable to those who are affected or aggrieved by their decisions or certain outcomes. Integration of AI tools or code protected as trade secrets may make it difficult for judges, magistrates, or disputants to understand how decisions are made, and may undermine traditional accountability mechanisms like the right to appeal. This lack of accountability may also arise when programmers or the software engineers embed precedent or statutory laws into code, making code rather than the law a guide to procedure and determination of disputes. This could complicate judicial review processes, which could seek to remedy erroneous or procedurally unfair decisions based on code. Opacity in AI algorithms, especially those using deep learning methods, could end up raising concerns about explainability in judicial decisions. For instance, lack of understanding of AI-generated judgments may lead to challenges to their impartiality and validity. And algorithmic judicial officers rendering decisions solely based on fixed inputs may violate principles of natural justice, especially regarding procedural fairness and the opportunity for parties to be heard. There is also the risk of bias and discrimination. We must be very cautious of this risk and ensure that the data used for training these systems is diverse and representative of our society, so that we can mitigate against ethical failure risks, such as those experienced in the US through their use of the COMPASS system. So the COMPASS system stands for Correctional Offender Management Profiling for Alternative Sanctions, and it is a widely used algorithm in the US criminal justice system designed to assess the risk of recidivism. That is the likelihood of an offender reoffending. However, there have been several ethical concerns and criticisms associated with its use. The last challenge is a lack of data privacy and security. There is a chance that personal data, case records, and evidence may be accessed in an unauthorized manner or manipulated by malicious actors. Okay, as legal professionals, we are faced with a crucial decision, whether to resist or accommodate an algorithmic judiciary. At this point, I believe it is best for us to accommodate, as this recognizes the inevitability that these technological advancements need to be implemented in our industries, and specifically our legal industry. So there are 3 algorithmic governance approaches necessary to make an effective algorithmic judiciary. They have been defined by Danaher, as a scholar called Danaher, as human on the loop, human in the loop, and human out of the loop approaches. I will define each one of them. The human in the loop approach includes the active involvement of human judicial officers in conjunction with algorithmic systems. The human on the loop approach involves human decision makers overseeing and intervening in algorithmic processes when and as needed. The human out of the loop approach involves the automation of decision-making processes without direct human involvement. Okay, there are various advantages to the, go back. There was the second session. Oh, this is the second session. The first session, there was Melvin and the other guy, and they said it is important that we have human intervention in our algorithmic systems. So it is best to have a hybrid combination of human in the loop and human on the loop approach in our judicial system, so that there is engagement of human intervention, and only the algorithmic systems will augment some of the tasks, routine tasks, and some of the case analysis, legal research tasks, helping the judicial officers make well-informed decisions, and also help court clerks do their work effectively. As a way forward, I believe we need to have a pilot testing system. We can start with the small claims courts, because they don't have a lot of money, and they have less emotionally charged subjects. And so it would be good to start with a pilot testing at the small claims courts, where we could have algorithmic judicial officers doing routine, simple judicial tasks and administrative functions. There is also the importance of having stakeholder engagement and collaboration. I believe that engagement between the legal fraternity, the judiciary, tech specialists, and policymakers is important to have an ethical and legal framework as regards the development of an algorithmic judiciary. And algorithms should be designed with the right human involvement. As I said, the best approach is the hybrid approach of the human in the loop and human on the loop approach to algorithmic governance. Okay, to conclude, the integration of AI and blockchain in Kenya's judiciary offers immense potential to streamline court procedures and improve access to justice. However, the challenges that it presents must be resolved through comprehensive discourse, pilot testing, stakeholder involvement, and ethical considerations. Also, human oversight is very necessary in this regard. By embracing algorithmic governance approaches such as human in the loop and human on the loop, we can harness the power of technology while upholding the values that underpin our legal and judicial system. Thank you, ladies and gentlemen, for joining me on this exploration of navigating the integration of AI and blockchain through an algorithmic judiciary in Kenya's judicial framework.
So thank you for that. So now, I know a lot of you are excited about, or I'm hoping that you're excited to ask questions. But just one, because we charge. So, you know, anyway, on a light note. So anyway, as I wait to hear your questions, I think what then I would ask the panelists, as guys get to think of their questions, perhaps then my question would be, do you think AI has any regulations in Kenya? And maybe I'll start with you. Yes.
Okay, so presently there are no enacted legislations or rules, but sometime in November last year, through citizen petition, we had the Kenya Robotics and Artificial Intelligence Society Bill 2023. This bill is still under works, so some of the key elements is that it introduces a society, that is the Kenya Robotics and Artificial Intelligence Society. The function of this society will be to, once this bill is enacted, to create laws and enforce these laws. There's also the regulation and licensing bit. So practitioners within robotics and AI will be required to register the organizations and to be receive licenses as the practitioners. Now the licenses are supposed to last for 1 year, subject to constant annual renewals. Then the other key aspect was that each county government was given ability to specify the requirements for registration and renewal of the licenses. Again, this bill did not receive, it wasn't accepted with open arms. Much criticism from key stakeholders being that they were not involved in the formulation of this bill. There's also some sectors that are saying that this bill just seeks to regulate jurisdictions that have put in place AI regulations, they do not per se want to regulate or control the sector. Rather than what these legislations do is that they ensure that human rights are protected even as we constantly engage with AI. So one key example is the European Union Act. Again, if you read the entirety of the act, you see that it doesn't necessarily restrict innovation. Rather, it caters for humans as humans. When we interact with this AI, our rights protected, our rights regulated for, even in the continuous engagement. So again, another key element is that non-registration includes a fine of 1 million and a imprisonment term of 2 years. But again, this is a legislation that hasn't been enacted yet. And going by the way the public has reacted to it, I don't think it will be registered in this current or present form. Yeah, so we still remain, I wouldn't say lawless, because although there is no 1 or 2 or 3 legislations that deal with AI and robotics specifically, we do have sector laws. So again, when it comes to tax, we have very elaborate tax laws. When it comes to tech companies that deal with capital markets, the capital markets also has very elaborate laws that do provide how these organizations are supposed to operate. Yeah.
So we open it to the audience. Any questions? You better have questions. We spoke for like a whole 1 hour here. You better have questions. Yes, please.
Hello, I hope you guys are doing well. I liked each and everyone's presentation. Apparently, I'll have like 3 questions. 2 will be matters in regards to AI, and 1 will be outside, but still in matters regards the internet. Because at the moment, I've been really keen on the internet since, let's say, 2018 till date. What I've been seeing in matters, let's say YouTube, maybe Instagram, any of the sorts, it's like you're driving on a highway. Your speed limit is, you have not been given a speed limit because there aren't the signs on the road. So you're driving at 130. Then all of a sudden, while you are on the road, an officer comes and stops you and says, we're going to fine you because you're driving past the speed limit. Why am I saying this? Yes, YouTube, maybe Instagram, they'll tell you we have terms and conditions. But when you go through those terms and conditions, they aren't telling you this and this and this is what you shouldn't do, or this goes against the community guidelines. They're not quite keen on that community guidelines, so you can't know this is breaking the community guidelines. So my question is, in regards to the law, is this thing going to be legalized, or we are going to have to wait and see how people experiment and go on up until we figure it out? That was my first question. My second question in matters in regards to AI, yeah? Since it's fairly new and people keep on finding ways and things to like add on, let me take a good example, yeah? Let's say I'm a content creator, yeah? Then I create my own artificial intelligence. After I've created this artificial intelligence, its purpose is to, let's say, I have my own personal website where after my followers on Instagram come to my platform, yeah, I have a chatbot there that actually helps them navigate through my website, my content, if they are to register to be a Patreon or something of the sort, yeah. If I use this AI to get their information, yeah, you are talking about every time they come in, there's supposed to be a prompt that shows that they've consented to this and that. Is there like a law that will govern that? Like anytime someone like comes to my site, it pops up just to let them know, or because at the moment what I've been seeing is more and more people come into content creation, then they have their own sites, then they get their subscribers to be like patrons where they pay every month and something of the sort, yeah? So my question is, will we be having laws in matters regards to like how the AI or how a content creator is supposed to be conducting the research and getting the information of each and every, let's say, customer that they have? And my final question is this, yeah? Because at the moment, what I've seen is there's personal brand, yeah? So if I have my own personal brand, will it be considered a company on the side, or I'm still a sole proprietor? Because I've not quite understood that, and I feel like all this personal branding, there are new terms that we are currently having, and I don't think I haven't researched to find out if there are laws matters regards to that. Yeah, those are my questions.
So I'll take the last two, the logo and the pop-up. And then I think you'll handle the AI aspect. Sorry? You'll repeat the question again, but let me first answer you. So in terms of the pop-up, it's just not a term that we're saying exists and people should comply. Now, we have a law that is termed as the Data Protection Act. Now, what that act does is it protects anyone's data that is in your site. So you're a content creator. You're taking in content from whatever service that you're releasing, right? Now, because you're assuming I come to your site and I give you my content, my data, and data being perhaps my name, my number, my email address, that's enough. Now, you being someone that holds my data, you need to protect it. Now, by protecting it means you need to have now a privacy policy that will tell me how you will store my data in the event there's a breach, because again, we might deal, and my colleague did address it very well in terms of the cyber security. Perhaps there's a hack. At that time when there's that hack, what will you do as the person that is holding my data for me to be sure that my data is safe? So that is why each time when I come into your site, for you to protect yourself as a content creator, so that you're saying you knew what was in my site, you'd need to have the privacy policy, right? So the privacy policy, given that perhaps there are some sites that have 10 paragraphs, there are some that should be very too long, depending on the service that you're giving and what you need the person to receive. Now, because you need to protect yourself, and I need to know my service or my data is safe, then what you need to do is you'll have the small box that says, I have read and accepted the terms and conditions, I have read and accepted your privacy policy. So that in the event now, perhaps your privacy policy might be saying, you can release my data to a third party. In the event I find my data, and I think we've received some of this information where during politics, and I'll use that as a good example, you receive messages from even people, perhaps you're in Westlands, but you're being told to go vote in Githunguri, a very weird place, and you're wondering, how did this politician get my details? Now, if you go back, it could be the various sites that you just subscribe to that you've consented and said, you can release my data to a third party for promotional content, right? So it's not just mere terms that you're saying, but these are things that are governed by law, that in the event you're not complying with that, given that you're holding my data, I can take you to court. Or we have now an authority that is called the Data Protection Commissioner. Now, they are the governing body. Before you even move to court, you can file a complaint, or the person who's been infringed can file a complaint in that body, and then they will determine. At times, they'll give you perhaps a slap in the wrist by a small fine. At times, they'll give the person who's been infringed a compensatory amount. So based on how you present your claim and how they appreciate it, right? Now, on the second one, if I did understand your question, you wanted to know whether personal branding or just branding in itself, there's also a law around it, right? Okay. Now, we have various acts that govern branding. Now, for personal branding, it's either you're telling that authority, perhaps if I use my name, Muniva is a brand, and Muniva is a logo, and there's no one else. Because remember, for you to present whatever you're presenting, there's no one in this Kenya should have it. Muniva perhaps might be a name that is around. So then you can't trademark it because then it is not your identity. That's the distinction. So in terms of branding, it would be there's a logo that you've created that you're saying is quite unique. You're saying it identifies your products or identifies your service, that you need it to be protected so that someone else doesn't come and say, hang on, I've been using this. In fact, perhaps people are confusing my brands with yours, which we've seen those cases where you're buying a product thinking it's this particular one, only to realize there's someone else in the market who registered it, and you can't have a claim. But so to answer you, yes, there are laws around it. It would just depend on how you want your brand to be identified. Is it an idea that you want it to be protected? Is it a logo? Or is it an invention that you've created? Or it could be perhaps software engineers. For software engineers, whatever you're creating, you need to copyright it. Because these algorithms or all this data, so to speak, is your mark or your identity. Yes. So perhaps you could you could repeat the question for AI.
Hello. So this is my question for the AI, yeah? AI is fairly new, yeah? And what we are currently seeing in the fast-moving tech world is that people find a way to keep on innovating and finding new ways to, let me use exploit for lack of a better word, to exploit the AI industry, yeah? So, as much as we all want it to be fair and square for everyone to come and play in the market, since we are finding new ways to use this AI that's currently being released, do you think that it will be fair setting up laws right now when the AI is new, and maybe these laws will stop something or someone from developing something that maybe might become of use in the future, but it will stop the law that we will have currently will stop the development of that specific product or something of the sort?
Okay. I think there are two perspectives to be considered, and there are two schools of thought to this. So there are some people who are saying, actually, this thing is moving too fast. We need laws around this to kind of limit it so that we can contain, even if it's a growth, it's not a rapid growth, it's a more structured, and we can predict the kind of steps to be taken next. And then there are some people who are saying, actually, since this is AI, the whole essence of AI is quote unquote an open market. So let everyone innovate, let the rules come after. And then another key consideration is the fact that there is no day where laws will be enacted before AI development. AI will always be a step ahead. So we will never reach a place where we have laws that cater for all AI possible variations at a certain point. And trying to do that is more or less a losing game. You're just chasing a wild goose chase. So the conversation needs to move from, again, like I said, when we're interacting with AI, our human rights protected. You see, now that is a more constructive discussion to have, where we are saying, even you as the developer or you as the subject yourselves, when you're creating this product, when subject matters of these products, are their interests, are their rights protected? I feel like if we have that conversation, it will be a more proactive one rather than discussing should we have laws governing all AI or which one should come first. Yeah. Because there'll always be one step ahead. There'll always, because laws cater for solutions, in as much as some laws, it's very rare to find laws that cater for future problems. Always laws are like, oh, I've hit myself here. Let's create a law that nobody can pass here. So yeah, it will always come after innovations. Yeah. And I also wanted to address that guy's issue where he's saying that we are the lords and inhibitors of innovation in Africa or funding. I think as of statistics from 2023, actually Kenya now ranks highest when it comes to VC and PE funding in the continent, attributing to 28%. And another key consideration is that businesses actually do fail with sufficient funding. So I think maybe in the past is where we said, oh, businesses are failing just because we are not funding. But now there is funding. Is the funding adequate? No, but where is funding ever adequate? There are other considerations that we should consider. One is capital structures of these organizations. Are there corporate governance policies set in place? Because we can give you money, but if you don't have management structures, if you don't have corporate governance structures, if you don't know how you're going to market or structure your product, then that money is going to waste. So I think gone are the days where we can say, oh, it's all just a capital issue. And worst case scenario, it's lawyers who are inhibiting capital flow into the continent. As lawyers, we only, and to use this term loosely, we only play with laws that exist. So I don't think there's any lawyer somewhere where he's saying, you guys don't bring money into this continent, or money comes in and we say, we're taking all that money. I think that's maybe a false narrative that I thought I should address. Yeah. And you have a right of rebuttal, by the way.
Just to add to what he said in response to your question, there is a foundational law, and that's the Constitution. And when you're developing AI, I believe it should align with the principles of the Constitution. Basic will allude to a few principles and rights, such as right to privacy, right to protection of our property. Those are foundational principles and concepts which need to be upheld when you're building or developing an AI system.
Trust a lawyer to give you statistics of how they're the best. But anyway, moving on. Let me chime in just to give a small comment on, but this is my personal opinion, has nothing to do with my company, nothing to do with this panel. Now, when it comes to AI and regulation, I tend to feel that as Kenyans, we got into this space, got to realize what it happens. Our regulators didn't understand. So our regulators played a back end of, oh wait, there's this new thing that's on the market. Let's understand what's happening. Let's put regulations. And that has always been my biggest complaint with regulators. They don't understand the market. They don't understand the product, but they copy and paste or mirror laws in different jurisdictions. Possibly, the AI bill in America or in UK will never apply to Kenya for one or two reasons. It's either for one or two reasons because our markets are quite different from the UK market. But then the challenge is men and women will sit down in the Senate and they will try to understand without even having the technical expertise in that field and impose laws. So in my opinion, do I think the AI should be regulated? Yes and no, in this way. Yes, but let them appreciate and understand this space. so that when they're coming in, they're putting fines or penalties, they appreciate what this space is. But that, again, as I said, and I very much give a big disclaimer, is my opinion. But yes. Any more questions?
Hi, thank you very much. My name is Paul, and I've really appreciated all your presentations. And when it comes to laws regarding AI, I would actually really like to appreciate what she just mentioned, that the Kenyan Constitution is the basis of all laws that we're going to pass, especially regarding AI. But I already feel like Kenya is already way too behind, and we should really act fast on regulating AI. Because first of all the AI that's already in the market has been developed from the West. And there's this question that I came across just last night. Can AI learn to be racial? Can it learn to be tribal? And of course, yes, it can. Because most definitely it's going to operate based on its base programming, depending on the developer who develops the AI. So I think you're way too behind. But other than that, moving away from AI, but I really think we are really behind. We should already enact these laws. But moving on, my question was regarding copywriting. You said if I have to copyright my IP, I have to copyright it in Kenya, and then I have to copyright it in another country if it's a global IP. But then there's another route. I came to learn of something called the Madrid Protocol. I don't know what that is. You submit your IP to the World Intellectual Property Organization, WIPO, through the Madrid Protocol, and Kenya is a member. There are like, I think, 123, 130 countries. And you can file for your copyright once and for all. I don't know how that goes. So I don't know if one of you knows how we can do that, because we would like to copyright our intellectual property globally. And the second question was, you said before you present your idea even to your professor, you should register this as a business first. But I was wondering, should I register it as a business first, or should I develop the product first, or maybe even get a domain? Which comes first, me registering a business, or maybe even registering a domain under that name, and I already have an existing website? Is that considered when you are talking about ownership of a product? Thank you.
So I'll answer the WIPO. So for WIPO, WIPO is it's an international body that governs now every trademark, every copyright, every just IP rights. Now the reason why WIPO exists is, remember, you might be operating in Kenya, but you, and I gave the example of money transaction, you also have a subsidiary or branch in Uganda or in Nigeria. Now, if you don't register it in WIPO, if you don't register it under WIPO, because WIPO is giving you the protection of internationally, the person in Uganda, you've not registered your claim there, or you've not registered your interest there. So the person in Uganda can actually use what you have and prosper. And that is why then, and that's the problem with our registries. Let me start by that. Our registries bring the Kenyan registry. Now, with the KIPI, so KIPI is the one that now governs Kenya. So with KIPI's records will not be reflected in Uganda's records. That has never happened and should not happen, because these are different associations, right? So the challenge is that and that is something that we've been trying to push, is us having a centralized place where all these records are there, because then it becomes tedious, even you asking a client, give me money for Kenya, give me money for Uganda, give me money for Nigeria. But because that's the status we are in, that's the advice we give the client. Let's register in Kenya. Do you have presence in a different jurisdiction? Yes, let's register there. Now, unfortunately, and that's also again, another hurdle that we have, Kenya and Uganda will not share these records with WIPO. So to also give another layer of protection, we need to now register it in WIPO. Again, as I said, it is quite tedious, but it's easier doing the registration now as opposed to you operating a brand for 20 years, thinking it's your brand. Only 2 years down the line, someone hits you with a claim that you infringe their rights. So that's where WIPO comes in and KIPI comes in. Is that clear? Yes. Now, let's start from the basics. Now, giving the scenario of you go and do your assignment, perhaps your professor tells you, good job, this is something that's, now at that time, it now gets back to you. Where do you want to monetize it, Or do you want to just let it be an assignment? And that's why, even if you create the domain, because if, again, looking at it pragmatically, if you create the domain, at that time, you don't even have the funding, you don't have the bigger picture of the business plan. You might register it, and that's fine, because again, as I said, for copyright, the fee is a bit small. For trademarks and patents, that's where the fee becomes a bit high based on the industry that you're in. But for copyright, it's a nominal registration fee. But because what you're trying to do is you're trying to tell the people around that you've publicized, this is something that is my originality, this is my creativity that I released. Then I'll ask you again, to what end? Fine, you've told the public it's yours, then what? Are you monetizing it? And that's why I think when I gave my presentation, I asked you, or I did ask the crowd, are you in the industry for articles or literature? So that's what you're actually saying, this is my book that I've released, and I want this originality to be known to me. That would be my view, but I think Victoria can address.
I agree with Munyiva. You need to know what is your objective. Like she said, do you need funding? Yeah.
You have not registered this business and through eCitizen or whatever platform, according to the Kenyan laws, but you already have a domain online, it's running, and you're making money from it, but you have not registered it as a business in Kenya. There are people who can identify that this domain is making a lot of money, but you have not registered it under your name. They'll go and register the domain exactly as it is, the domain name, as a business name in Kenya, and then claim it to be their property. So, which comes first? If I was ever to contend that person in court, I had the domain first, I had the business running, I registered this domain in 2018, you registered the business name in 2020. So, whose business is it? Is it your business or mine?
Okay, please repeat the last.
Sorry, just even on a general basis, registration gets first right. So if you had the idea, but I happened to register it, I'm the one who registered it first. I'm sorry for your loss, but it's mine. Yes. Because again, you'd want to go into the issues now of, I'm claiming to register it in March, but you're saying you operated it in January. But what stopped you from registering? I mean, that's a very simple question that you'd be asked. And ignorance is no defense. You can't just say, I didn't know. This is your product, you actually have a duty to know these things and register these items.
And a domain is actually a company asset. It has to fall under the company's name, so it is best to register the company first. And then there's this.
All right. Hello, everyone. My name is Joy Impano. I also happen to be a lawyer, and I thought to chime into this conversation. There was a move to have our registries communicate to each other. So our IP registry communicate with our company's registry, because like you said, there would be an individual with IP registered, and then someone else registers a company with that name and claim, and then lays a claim on that asset. So there was a push to have registries communicate, so that by the time you're going to register a company, you do know that every time you register a company, you're going to be asked to provide names, and then they're going to look through their systems to confirm whether those names are available for use. So you see, if these registries don't communicate, then that name might still be available for use, because as far as the company's registry is concerned, that name is not registered along a company, right? So to protect you, I think the answer, like my colleague has said, that it might be useful for you to actually register both to avoid the scenario where you have to fight for your IP with a company. So think about it as I need to protect my IP all round. To avoid that fight of, you might have registered the IP with that name, but someone else went to register a company under that name, and then it becomes litigious on who owns the IP. Of course, ultimately, when we are looking at who owns the IP, we'll go and look who registered the IP first, which that might be you, but imagine by that time, maybe he's passed off as the owner and taken some of your revenue, right? Before the court ultimately determines that you own the IP. But yes, there is a push to have our registries communicate with each other so that by the time I'm going to register a company, I can check whether there's an IP related to that name, and then that name becomes unavailable for use. But before we get to that point, it might be useful for you to register your IP, but also a company, especially if you're trading under that company. Think about it even from a KRA perspective, because if you find that you're running a business, virtually of course, but not registered as a business, which is an avenue for them to make money, they might come after you. Unless you're trading as an individual and not as an entity owning the IP.
Okay. Thank you for that, Joy. Because of time, I think we can take one last question. That guy. Or maybe we can, I think this guy, his issue, we can talk about it, but maybe this guy, we don't know his question. Yeah.
Hello, my name is Derek. I have one question. Because WorldCoin was suspended in Kenya, who has that data? Is it safe? That's my question.
Presently, the data is frozen. It can't be exploited and it can't be extracted out of Kenya because, again, as we discussed, no consent was given for obtaining this data. And another key element of consent is that if I approach you and make the consent non-negotiable, then there is no consent. So again, no consent was given. It was aimed to transfer out of the country without safeguarding measures in place, and no that protection impact assessment was done. So as it stands now, they do have the data. But again, as the matter is still in court, ultimately we aim to deprive them of that data. Yeah.
Ladies and gentlemen, I know this can go on and on and on and on. I wish to ask that we appreciate the ladies and the gentlemen for the wonderful presentation that they have made. And this marks the end of our today's sessions. Tomorrow we have very interesting topics on data protection, cloud computing, and IoT. So don't miss tomorrow's sessions, starting from 9 a.m. and ending at 6 p.m. So after this, we have an interaction cocktail outside there. So if you had a question, if you have blocked you from asking a question, the ladies and the gentlemen will be around, so you can talk to them. Sawa sawa. So this marks the end of our day's session. I would like to appreciate all of us who have participated for being very cooperative and being very patient. Looking forward to have you tomorrow. So, yeah. Thank you so much. Let's appreciate our presenters once again. So, I would like to ask all of us, we can meet at the entrance there. There's a cocktail going on. All of us are welcome. Feel free to interact. Feel free to talk to the advocates on your questions. And see you. Have a wonderful night.